It's 6, okay. I'd like to call to order the Board of Zoning Appeals meeting for Monday, July 26th of 2021. First item of business is to approve the minutes from the last meeting.
So moved.
Is there a second?
Second.
Has everyone had a chance to review those minutes, because we're going to be continuing that meeting tonight, so we'll make sure everyone's had a chance to review those. Okay, all in favor of approving, please raise your hand and say aye.
Aye.
Okay, they're approved 4-0. We'll now move into the variance request that we continued from last time. Let me just explain how we're going to do this. Last time we tabled this, we'll bring it back off the table and open it for further consideration. First thing we're going to do is hear from staff. They're going to clarify the ordinances that apply here and what the rules are. We'll ask Ms. Compier to do that. Then we on the board will discuss that and make sure we all understand what the rules are. Then, before we consider it any further, I'll give anyone in the audience who wants to have something to say based on all that conversation, you'll be able to do that. You don't have to go over anything. You don't have to say anything you don't want to, but you'll have a chance to comment. Then we'll take the matter up for consideration and finally reach a conclusion. Is that process okay with the board?
Yeah.
Board okay?
Very reasonable.
So, first order of business then would be to, let me say this. I'll state what we're discussing. Variance request application VA 21-008. Property owner Denise Surratt is requesting a variance from the 25-foot setback requirement from the permit mobile home at 203 Newport Road, Seneca, South Carolina 29678. The tax ID number is 292-00-03013. I hear a motion to bring this matter off the table.
So moved.
Is there a second?
Second.
All in favor, please say aye.
Aye.
Aye. Okay. Motion is carried 4-0. So first order of business, Ms. Compier, would you please bring us up to date on what you see as the ordinance involved here?
Okay, I'm going to try to make this as simple as possible. There was, hold on, put it in here. Mr. Chapman, who was the previous planning director, approved a site plan 25 feet from the property line, which was correct. And I can tell you why right here, because the driveway from 1 to 3, there's no standards, which means this driveway of Newport Road comes in and accesses 3 lots. Ms. Surratt's at 203, the lot behind her, and 268, the lot behind them. So that is technically a driveway. So that's why the site plan was approved 25 feet from the property line. It took me about a month or two to understand this myself. It's not easily understood. So I'm going to try to go in a little bit farther. This was a subdivision that was platted years ago, 2003, which I think brings a little bit of confusion to the right-of-way. There is no right-of-way. This subdivision never happened. So the plat that got re-recorded was this one. So that subdivision does not exist. That driveway only accesses 3 lots. So there can only be, right now, there can only be 3 dwellings, which would be either lot 25, lot 26, or this 21 acres. If the owners of this 21 acres wanted to subdivide it all, then that right-of-way would have to go in. But as of right now, the site plan was approved 25 feet from the property line, which was correct. So Miss Surratt's front porch is in that 25-foot. That's why we're here. We need to do something about this 25 feet in the setback. Questions?
Let me see if I can paraphrase what you said. If you can go back, we originally had a plan for a subdivision, which included a number of home sites.
At some point.
At some point, we had that, and so originally it was platted, and there was a road platted to access that. That road had a right-of-way of 50 feet, and then because that was a private road, a private property, the property lines then were still set at the center of the road.
Correct.
So that so the property line was set, and that's where we got confused last time, is where's the property line and what is the rules? Now, that subdivision has gone away, and so now we only have 3 parcels. We've got the 2 that Ms. Surratt owns and one over a larger parcel of 20 acres. So there's only 3 parcels, so if you look at what the county's rules are for accessing 3 parcels, that's termed a
Driveway.
a driveway. There is no standard for right-of-way, and there's just no standards that apply. So that driveway can really meander anywhere you want on the properties. There's no standard where it has to be, how wide it has to be, and where it goes, okay? And so last time, we agreed that the trailer itself was 25 feet from the center of the road. Both sides agreed to that, and therefore the trailer is situated okay. The only issue we're left with is the front porch, which sits inside the right-of-way. Is that making sense to everybody up here? Yeah. 2 guys who weren't here, I think it makes sense to. Are we all square? Okay, so we're all agreed on that. That making sense? Okay. Given that, does anyone in the audience have anything further to say? I do. Let me ask the variance requesters first. Please come up and state your name.
Yeah, my name is Jim Pearson.
Yes, Mr. Pearson.
I was a real estate agent involved in this with these folks as well. How much is the porch encroaching in that right of way?
Ms. Surratt would have to answer that. It looks to be like it is the entire porch. We can't ask to have a survey be, we can't ask for a survey.
Okay.
So,
Can we say it's about 4 feet? 3 or 4 feet?
Say 3 to 4. So is there still enough room to have a small stoop, you know, if we take off part of the porch? I would like to add that when this property was first for sale, Mrs. Porter in North Carolina that owned it agreed. I told them, and I said, these folks are buying this 20 acres, and you've got this little slice along the road, which is just on the other side of the road from Mrs. Surratt. And I said, you can't do anything with it. You can never build on it. Why don't you just throw it in case they need to move over that driveway or widen it or do something else? That gives them a little more flexibility. And she agreed to do it. So they've been given that slice of road in that driveway to move over a few inches. I don't know what the problem would be with doing that. It wouldn't take any excavation or anything, just a little gravel. As a matter of fact, she'd probably be willing to pay to have it gravelled. But I think we're asking here, we were asking for a variance, but if what I'm hearing, it sounds like we don't even need a variance. It sounds like she's in compliance except for that few feet on the porch. But if they're willing to move that driveway over a little so we can leave the porch where it is, we'll pitch in some rock. That's all I have to say.
While we're at that, on that subject of the porch, is there any possibility, do you have a door in the back of your trailer?
Yeah, there's a
So you could put an entrance way back there?
Yes, we
But will that meet code? But I don't know if that'll make code, because.
I have no idea.
She's supposed to have two, she's
You have to
supposed to
have
have two.
You have to have two, a
Yeah.
front and a back.
No.
Especially in a mobile home, you'd want to. Well, here's one thing to consider also. You're dealing with gravel and not asphalt, so you don't have a neat straight line. I imagine if you go out there and you pull, that gravel migrates over as traffic goes up and down. If you've been on a gravel road, it may start out this wide, and over time, it just creeps out because the rock just keeps getting pushed out. So I understand, to me, if your mobile home is outside the 25-foot, basically trying to find where that center is, because that center line is doing like this all over the place because of gravel moving out. I just have a hard time telling somebody they gotta take a stoop down. Because if you've got a nice, if it's uniform, if it's a uniform road down through there, and you've got center line, and you can pull 25 feet, that's one thing. When you're working with gravel, there's a good possibility that you move up the road just a little bit, and it's not even close to being, that would be encroaching.
Well, we did have a survey that was provided actually by the folks questioning the location of the trailer that showed that the trailer was 25 feet from the property line. Property line being about the center of the road.
Wow,
We weren't measuring,
right.
no one's trying to measure from the center of the road, people are trying to measure from the actual surveyed property line.
Right.
That's,
So there should be a nail or something out there that could be found.
I guess, yeah, but
Yeah, if you're a surveyor, yeah, you're gonna put some kind of marker somewhere.
So basically, we're looking at a variance of about 4 feet.
about.
Yeah.
Before we go too far in our discussion, I'd like, does anyone else have anything they'd like to say?
Yes, please.
Yes. This is Mr. Bagwell, right?
My name is TJ Bagwell, Bagwell and Corley Law Firm, representing the owners of that larger tract that you mentioned, the Varela, Varela. I have, again, a few documents, if I may approach and hand everybody a small package here. These are put in order from the oldest being the top one. This would be a complaint from
May I?
certainly the owners of that tract. And the oldest, that, I just put it in there just to show that the date of that complaint is April of last year. From there, you'll see also in April of last year, Mr. Adam Chapman, representing the county, sent a letter to, these were all provided by the Freedom of Information request. Mr. David Root, the county attorney, provided these for my clients. So this was of course, about the 203 Newport Road, the zoning violation. This was sent to Ms. Surratt. You can see that third bullet point says that when the mobile home was the permit was applied for, that the platted 50-foot easement was not even made part of that permit request. That, of course, was registered with the Register of Deeds, so it was public record, easy to get to, but was not made part of that permit request. Below that third bullet point, I'd like to point out that the Mr. Chapman says that the setback requirement is 25 feet from the edge of that right-of-way. So you can see that well over a year now, Ms. Surratt has been given this information that the not only was the permit application for the mobile home incomplete because it did not have that very important piece of information of the 50-foot right-of-way, but also knowledge that the 25-foot setback is not from the property line, as we've discussed, not from the center of that right-of-way, but from the edge of the right-of-way. So it would be 50 whole feet from that center line that the mobile home should be set back, not 25 feet. First half of the right-of-way, of course, 25 of those first 50 feet, and then another 25 from the edge of the right-of-way. Some information on the next 2 pages was included in that letter from Mr. Chapman. It's all pictures and plats that we've seen up here before. Another letter, this is a little over a month later, May of last year, again with the same information. Mr. Chapman confirming that the important information about the 50-foot easement was left off, and then that the setback requirement is 25 feet from that easement. A letter in August goes further and says 2 notices of violation have been sent, and the mobile home was moved without further permitting. That paragraph goes on to say that, once again, it's not meeting both it's encroachment on the property, and it's not meeting the 25-foot setback. So I understand we had some issues last time. Was, should Ms. Surratt be left alone? Had the government done too much to her already? But that's quite frankly not the case here. Is the permit application to start with was incomplete, leaving out that 50-foot right-of-way, and then she was given warning for well over a year now that not only should that be off the right-of-way, but another 25 feet back from that spot. The last page is just a picture that was taken this morning. That's a car. I don't know what Ms. Surratt drives, but it is a car parked not only in the setback, but out there near the middle of that right-of-way. My clients have had, as you know, the housing market is extremely hot in Oconee County. They've had 2 inquiries in the last month from developers about this property. They had to call and have a truck. Maybe he can tell you more specifically about what kind of truck it was turned back. But in my experience as a real estate attorney, just I believe as you were alluding to earlier, that right-of-way isn't there to try and make as skinny a driveway as possible. That whole 50 feet could be paved. That whole 50 feet could be asphalt or concrete. It could be used in any way they wanted to for a 4-lane highway back there if they like. That's their right. I mean, that's what the right-of-way is for. And to then set a mobile home right on the edge of that, what could be trucks going through there, what could be cars, any type. The setback is to move that property or move that home off of what could be a paved, used road. As you can see from that picture already, it would be difficult to get a utility truck back there, difficult to get a concrete truck to pour footing on a house. If any developer, whether it be my clients or some other developer, is going to develop that, then I believe it would be the county's best interest that everybody follows their rules. Of course, those contractors that build houses back there are going to need permits. They're going to need to follow those rules. Well, yes, and I expect that. But shouldn't everybody on the way in and the way out also be there following the rules? And according to Mr. Adam Chapman here, of course, representing the county, speaking on the county's behalf, when it comes to the zoning violation, it's that not only should the 50-foot easement be respected, but also a 25-foot setback off of that easement. And so we would ask you to deny any type of variance in that mobile home and the porch moved all the way back out of the easement and out of the 25-foot setback. Any questions?
Appears to me the key consideration we have here is that you're continuing to say that the county's previous representations were that a road right-of-way does exist.
No.
What we're hearing this morning is that the plat for the subdivision has been rescinded, has gone away, and therefore a road right-of-way does not exist.
But that, even if a plat had been rescinded, that doesn't make it Ms. Surratt's property.
And I asked a quick question. Are they paying taxes on all of the individual lots, or are they paying taxes on the whole parcel?
Right now, it's the whole parcel at the moment. However,
Come on up, please state your name and,
Their individual plats we're paying on right now.
no, it's the name.
please state your name and
Hello, my name is Danny Varela, and I'm the owner of the property that ends in 3036. It's the 21-acre lot.
Okay.
So I'm sorry, can you repeat your question for me again?
My question was, were you paying per lot like it was a residential subdivision, or were you paying per acre or are you paying for the acreage tract as a whole?
Right now, I'm currently paying for the track as a whole.
Okay, so-
However, I think what needs to be clarified also is that when this development occurred, there had already been water and power run out to all those plots. So that infrastructure is already in place currently. And in fact, let me also go back, because I'd have to rebut what was said earlier about that right-of-way not being in place, because when we bought the property back in February, March time of 2020, we were told specifically by the attorney that we had to abide by all restrictions, covenants, ordinances that were in place. And one of those things that he actually called out, as well as a surveyor that we had talked to as well, was that there is a 50-foot right-of-way that exists, that's platted, it's there. And that we had to abide by that. So right now, even as we are looking to put a home on the property, which we're working on right now, we are still adhering to those ordinances, requirements, covenants that have been established by our deed and the plat as well. Now, the other thing is to point out is that you do have that survey. In that survey, there's actually a number there that states that Newport Road is a registered road with the county.
It's showing up as a private road.
Correct, but it's also registered. So the county has gone in and actually registered the road. And I was actually looking at it. It is number, I can tell you, P 4238.
Does your deed specify the size of the right-of-way?
50 foot.
It says that you have a 50-foot
It says-
right-of-way all the way into your property?
Correct. And I have easements that are currently sitting out there due to public and electrical. So they ran power and water out to all those anticipated plots that are out that due to the failed. So it's all sitting there. It's all easement. There's a 50-foot right-of-way and an easement that I have to abide by as I build. So even though we're trying to say right-of-way or driveway, the fact of the matter is that what is currently platted and deeded is a 50-foot right-of-way. That, and the thing is when we were talking to the attorney, we were fighting it back and forth because we wanted the ability to do what we wanted with the land. However, they told us, unfortunately, it was deeded and platted, and that 50-foot right-of-way exists.
Now, you're entitled to a 50-foot right-of-way. Now, the gentleman previously spoke and indicated that the owner of the tract across the street would be willing to sell some portion of that to allow the 50-foot right-of-way.
That's even inaccurate, because that whole transaction was done well before it was a land swap that occurred between Dr. Stone and the previous owners that we bought it for. And it was a swap of interest in the land and another 1.3 acres in exchange for a couple other acreage. So it was a land swap that occurred basically to let access into that property.
But if
Which-
they're,
oh,
no,
sorry, go ahead.
the question is, if they're willing to sell a portion of that and the party's willing to pay for that strip of land to make you whole on your right-of-way, then you're not harmed at all, are you?
Well, the only way to do it would be go to the neighbors south of us,
Yeah,
the Burns, who own
That's
own
what
that
I'm-
who
right.
own that land.
that's tract D, right?
No, they are actually, they're Richard A. Burns, D-Book
That's
1097
listed on
H.
on this particular thing as track D.
I'm sorry, are you showing that one?
Shows it's the property opposite the
On
trailer.
the exhibit that,
Yeah, one
Back
of your own
on
exhibits.
I'm sorry, what,
This one.
oh, yes. Okay, let me go to it real quick.
So, I mean,
Give me a second. Okay, track D is actually the lot that my wife and I currently own. That is the one that was involved in a land swap between Dr. Stone and the previous owners, the Porters, that occurred. So we currently own that land, that parcel, which allowed for ingress, egress into the property. And I do have to add, that was brought up last time, is that this is the only entrance in and out of our property. There is no other way in or out. So unfortunately,
but if the party were willing to pay you for a strip of that land, to allow that for that road to be shifted 25 or 50 feet towards your property, the new property you bought, what harm would that do to you?
I guess I don't quite understand the question you're asking.
If you
he
were
already
to-
owns the road.
I already own that track.
Owns
Yeah,
that
he
track.
owns the
Track D
but
I
they're-
own, the 1.1.
But my point is, if they were willing to buy, you own
No,
the track,
he owns-
if they were willing to buy some of that land,
He owns this piece right here that you're
I
talking about.
understand, I'm talking about that.
Yeah,
no.
he already owns it.
I understand
He
that.
could move his
But
road,
what I'm
he could
saying
move his
is,
road onto his own property with no problem.
that's true.
He already owns it.
I agree with you. But what I'm saying is, if they were to compensate you for that, for the loss of that land by shifting the road south, would that be a solution?
Well, here is where I think here's kind of the issue that I'm running into is that in doing so, you are taking away the ability for us, my wife and I, if we decide to develop, to turn that into a neighborhood.
Yeah, but
Which
we're talking about like 50 feet off of it.
Well, but if you're going by county guidelines, then anything over 11 is a 50-foot right-of-way, right?
I
Can we
think
go
we're getting a little
back
bit
to that slide?
off track here.
So even if we were to, so that's, and I understand what you're saying. However, what gets taken out of our hands is our ability to do something with that land down the road. And initially, it was a failed subdivision. Now, what if my wife and I decide that we want to sell to a developer and allow them to develop that property? And in that case, then you have another 15 homes that could go into that property. And by county definition or by ordinance, anything over 11 is a private road and therefore is also 50-foot.
I think we all understand that an issue may be that you want to develop the land, and you need a 50-foot right-of-way to get your road back there. The issue before us is, where is this trailer in relation to setbacks? And I've heard one version that there really is a right-of-way there, and that the setback needs to be 25 feet from the right-of-way. And the other version is, well, there's really no right-of-way through there anymore because the subdivision has ceased to exist, and therefore, the setback just needs to be from the property line.
So I do actually have another thing to add as well, is that if we go back to Ms. Surratt's plat and deed, it's also deeded as a 50-foot right-of-way as well. So her own deed and plat call out a 50-foot right-of-way.
Okay.
Well, I'd like to ask this, just to get the timeline straight. I see here that this plat was recorded on April the 3rd of 2020, your plat.
Yes.
And a complaint was made on April the 7th, 4 days later.
Correct. So so initially that complaint was due to the road being blocked. And so enforcement went out there to help open up that road in order for our contractors to get in there and work.
So the mobile home was already there.
Correct. The mobile home was placed in April of 2019.
Okay, 29, so the mobile home been there for a year.
Correct.
And then the supposed development never occurred. And you came in and picked up you picked up that parcel of land, correct?
Correct. In February, it was recorded, I think, in April of 2020.
So she already had her mobile home there, and she already had established at some point, wherever this right-of-way was, then I could think, Mr. Conner, this goes to what you were saying, then if that development went away, I would think that the right-of-way would go away also.
Well,
I think so, too.
that's,
And
yeah.
I
I
think,
think that's what, Ms. Compier, is that what you're telling us? That the development's gone away, so therefore the.
That's-
Development went away when they stopped paying lot taxes and
Yep.
went to having it as a parcel of more land.
So the development's gone away, so therefore is the right-of-way gone away?
Correct.
Ms. Compier, you're saying that's true?
Yes.
Well, okay, so I do have a
I hear,
question.
these folks are, that's what I'm trying to
Okay.
clarify, is what the county's position is.
Well, but the other thing is that in nowhere legally have those right-of-ways gone away. I mean, legally, by deed, by plat, those right-of-ways still exist. And in fact, just recently, when I purchased the land, legally from our attorney, the title attorney, they said, you must adhere to that 50-foot right-of-way because it is deeded and platted.
but you have a new plan.
You have a new plat.
I have a new plat that says or still establishes that 50-foot right-of-way. There is still a 50-foot right-of-way and still easements in that, on that property that still are tied to that 50-foot right-of-way. And we do pay taxes on 3 individual lots.
Okay, do you have anything else you'd like to add?
I'm good for now, unless something else
I
pops
think,
up.
is this your wife over here? or
Yes.
I think she wanted to say something?
Oh, I just,
Welcome to it, ma'am, you're welcome to. We want to hear everyone's point of view. State your name, please.
my name is Trisha Varela. No, I just wanted to say that we did pay 3 individual tax lots for this. It's not as one whole. They each have their own plat number. So we paid 3 different tax amounts, just to clarify that piece of it.
Okay.
'Cause I
But you
wasn't
own
sure.
one parcel.
Yes,
Yeah, it's the one parcel, about 20 or 21 acres.
yes, correct. Thank you.
For now, actually, because when we put our house on there, then an acre of it comes out of it. Now, I do add that we
So
placed that.
you
land-
have it under agriculture assessment?
It's currently under agricultural right now for the time being, until the home gets put on the property. And then in that case, then it changes. Now, what we've done, because of the easements, the restrictions, we've placed the home in what was designated a plat. So we're following the existing plats due to the current easements that are in place. I mean, the county, or at least far as Seneca Light and Power and Blue Ridge, all have those easements in place. So they're sitting there right now, and we have to abide by those as well.
Vivian, would they have to go back for a whole new plot plan for that facility if they wanted to develop it?
For the subdivision?
Yeah.
Yes,
So at the present time, it's just one big lot,
yes.
and it's being taxed as one big lot.
I can't tell how it's taxed. This is their deed I pulled
Right.
up. I have 2 tax numbers on here. Now, I'm not sure, let me see where I am. I have to move that, I'm sorry. I have one of these actually shows it as a little piece of property. I'm sorry, it's on his exhibit. That shows it as a little piece of property. That may be the second tax map number. I don't know, I don't work in the assessor's office.
Yeah.
But on the deed, it has two different tax map numbers.
If you look at the top of the page,
There's this one.
yep, 292-0003-057,
So it could be,
and that's the second parcel number.
oh, here it is, here's that little piece. Is that the little piece that could be a different parcel number?
Yes, when you look at the top of the page.
But we've all agreed that we're talking about one large parcel, the lot 20 acres. And I'm not sure why it's germane how they're taxed. I understand that it may have some thinking process.
Once you
but-
put it all together under one parcel number, that's when you do away with the subdivision.
Yeah, right, okay, so, okay, so,
However, I understand that, but legally, that road still exists. The road still exists legally.
we're being told by the county that it does not exist, so that's,
But, but you haven't gone through and updated our deeds. The deeds haven't been updated then to legally.
I wonder if we need David Root here to advise us.
No, we don't. It's clear, she told us. It's 3 parcels. 3 parcels makes it a private road, makes it no rules about the 50.
If I may,
yes.
it is Newport Road, which is the named driveway. I got so many things open here. And let me go back to my. It would have been, the name of the road would have been changed to Maplewood Lane, and it did not change to Maplewood Lane. It is still Newport Road. And it does get a number because for 911 addressing, we have to have those
Sure.
P numbers.
Yeah.
And P is for
Private.
private.
Right. Okay. Then it's been established.
What's been established?
I've been established, it's a driveway, then from a county standpoint.
It's a driveway, yes.
Yeah.
Mr. Chairman, if I may.
Yes, Mr. Bagwell, please.
Would you please scroll up to the, I believe it's the plat just above this one? I don't think rejecting the presence of a right-of-way is in the county's best interest, of course, or my client's best interest, but I also don't believe it's in the best interest of the petitioner. That other plat,
And I'm sorry, I don't know which one you're.
What are we trying to find here? Let's find that and then.
it's the one that highlights 25.
This one?
No, I'm sorry, it's, it has lots 25 and lots 26 on it.
This one has 20, it's not, I mean, it has it on here. Make it bigger for you.
Yes, that'll work. So I'm sorry, that was the right one the whole time. But if you reject that there's a right-of-way here, then the petitioner won't be able to go home tonight. That stone drive is completely on the property of my clients. That's, I'm sure it comes down through the subdivision there or through another road, but the entirety of that driveway, obviously its intent was there was to be a right-of-way there. If it's declared by the committee tonight that a right-of-way does not exist, then my clients own all that property that is in that black outline there, which includes the entirety of that stone drive, which literally means the petitioner would be landlocked. I say that not as a threat, not as anything like that, but it doesn't make sense for the
We're
county.
not here to decide whether or not the driveway exists. We're here to decide whether or not she gets a variance for her porch.
I don't think she wants the variance,
Why not?
because she would be landlocked and literally would not be able
No,
to
the
get home
variance
tonight
will
without
only allow
trespassing.
her to set her porch where it's at. That's all we're talking about. We're not talking about roads.
No?
Okay. Anything further from you folks?
I do have one last thing that I wanted to add.
Make sure everyone gets heard here, and then we'll.
And so I do have one letter that I think was left out, that actually was sent by Vivian back in April, which said the same thing. In April 14th of 2021, Vivian had sent a letter saying that, that 203 Newport Road was not meeting the county's 25-foot setback requirement. So this came recently as well, stating the same thing, that it wasn't, that they weren't adhering to the setback. And that wasn't part of it, but I do have the letter here from the county, if you want to have a copy of that. I can hand this over to you.
What does this say?
Try to find it.
Okay. This is a letter from Ms. Compierre dated April 14th of 2021. That's just a couple of months ago. Mobile home at 203 Newport Road is still not meeting county's 25-foot setback requirement, and so on.
That's why we're here, sir.
Okay, well, so,
Because that's.
and why did you say it's not meeting the 25-foot setback?
I wasn't aware that the mobile home was moved, because the permit wasn't pulled. Her contractor didn't pull a permit, so I wasn't aware that the mobile home was moved. So now, it's not the mobile home, it's just the stairs.
So, just to review a little bit, when the trailer was initially placed, it was placed at an angle, it was a little bit, if you'll excuse the term, cattywampus, so it did encroach on the 25-foot any 25-foot setback, and Ms. Surratt was advised of that. She had the mobile home moved then, so that the mobile home, I think we've all agreed, is about right at 25 feet from the property line. And the only issue then is that's less than 25 feet is the front stoop. Have I got that right? Who would agree with that?
Maybe.
So that's what you're talking about then?
That's what your
Ms. Compierre was,
point, yeah.
at the time, you weren't aware because she had not pulled a permit to make the change.
The contractor.
The contractor
has to pull the
had not
permit.
pulled the permit. They weren't aware that she had relocated the trailer to be in compliance. Okay, so that's what this is all
That was the
about.
reason for the letter.
That's what this letter is
Right,
referring to then.
because
It's not referring to, hey, it's 25 feet off, it's just a few feet off,
Right, correct.
which was then corrected. So,
Yeah.
okay.
Maybe.
You need this, this is an evidence though, so I need to keep this.
Yep, you've got it.
Okay.
However, I think that the other piece is that, I mean, it's kind of hearsay. I mean, I can say I've done something, but then necessarily said I did it. So there's nothing out there saying that it's actually out of the right of way.
Okay, now last meeting, both sides, Mr. Bagwell, I believe, and Ms. Surratt both said agreed that it's 25 feet from the center line,
I don't know.
from the property line.
Well-
We agreed to that. If, that was generally agreed to on all parties. We got it in the minutes.
Okay. I'm just saying that there's nothing officially saying that it's outside of the right of way, other than just.
Well, if you want to present evidence that it's outside,
Well, we were
It's
the
not
ones that
accurate?
presented the evidence that it was within the right of way. It's not, I don't think it's supposed to be my job to say whether or not somebody's done something. So,
okay.
I'm just saying,
Yes, sir. Thank you for your input. You have anything else?
I'm good for now.
Thank you for your input. This is kind of your last chance, so if you got anything on your mind, please let us know. Okay. Ms. Surratt or,
I'd like to say, you
Pearson.
mentioned, BJ mentioned a little bit earlier that there wouldn't be room for emergency vehicles in the last meeting, and then he mentioned it again, that it was too narrow for certain, they drove a bulldozer through there today. And there's still plenty, they could have driven 2 bulldozers through there if they wanted to, so I don't think that's an issue. And I don't know if that's an issue in you making a decision, but there's plenty of room to get traffic.
where I come out on this is all private property. You folks got to come to agreement on that. We're not here to judge that.
All right.
It's private property, and you guys are all going to have to get together and figure out how you handle your private property. Okay? Is that making sense to everybody up here? Private property, they gotta get along.
So,
Okay.
can I
Now, sir, I
ask
think,
one? Well, you're about to make a decision, and my question is going to be, let's come up here.
come on up to the podium, please.
Not for vote. Can I just, okay, I'll wait.
Oh,
No, best to get it out now if you want.
Well, okay, so.
We're not gonna listen anymore.
Okay, so.
We've heard enough.
I apologize, but my question then is, let's say, I mean, if you do decide to say that this is a driveway, right? What happens in the event that we want to sell to a developer, or we want to parcel out, and a developer comes in and they start putting more homes on the property that then adhere to whatever the standards are? I mean, what then? So,
Danny this is private property, and you guys are gonna have to come to an
That's
agreement.
right, but.
We're not here to legislate an agreement.
I know, however, the stance you take now, not only impacts what we can do in the future, but it also sets precedents for others down the road as well. So.
Our
if-
hearings do not
we don't set
set precedent. We do not listen to precedent, we don't try to worry about precedent. We judge each case on its own merits.
But they can come back and point to this one.
They can point all they want, but we don't discuss precedent.
Okay, so then gets back to my original, is that based on your decision right now, you have an impact of what my wife and I, or even children down the road, can do with that property.
Understand?
If we decide that we want to develop that property, then we become hamstrung in that egress into that becomes much narrower. So trying to get two cars in and out at the same time becomes undoable. We can't. I mean, you can only get one car.
Understand, that's an issue you're gonna have to resolve with the owner of the property at that time, Ms. Surratt or whoever owns the property at that time.
Right, but I'm asking you right now, based on, when you make your decision, to think about that part of it.
Okay.
Because
Certainly take that into
that
consideration.
decision would then impact what we can do with our property in the future. And right now, only one car can go in and out.
I understand your position, I understand what you're saying.
Okay, thank you.
Thank you. Okay, we're done with input from folks. Thank you very much for your time. I hope you appreciate that you've had a chance to say your piece. Okay, how about we do this? Let's have a motion to grant the variance with a second, and then we'll talk.
So moved.
Second.
Second? Okay, discussion. Where are we on all this?
Honestly, I agree with what you'd said. It appears that it is a driveway, not a road. As far as precedence or anything else, if it had been that this couple had bought it, began developing it, she moved in, and was within that right of way, I would sit there and say she should have known better than, or whoever put the trailer there or mobile home there, shouldn't have put it there, should have moved it back. But since it was there for about a year, roughly, I think everybody agreed to around that time, it was there, and then they start talking about, we're gonna make it a road, and now it's gonna be a 50-foot right-of-way. I think that you've got a situation where someone was already there, and I don't think, if we do that, we can start changing around anything anywhere.
Well, and I think the second thing to take into consideration is that the parcel was subdivided.
Right.
But then he combined it and he's being taxed as a whole, which means he's paying almost no taxes as opposed to paying lot taxes. By doing that, he did away with the subdivision and made it a parcel. He turned it into a farm by tax standards. If he had intended on it being a subdivision, he should have left the lots there, deeded it as lots individually, not as a parcel as a whole. It should be showing lot 26, 27, whatever of this subdivision. It was not done that way. So in my mind, it is no longer a subdivision.
Ms. Campier?
We have the 4 questions that we need to answer?
Yes, we'll do that.
Okay.
We'll do that. We'll do that. Okay, I guess maybe I did. Okay, so we're discussing, we're going to answer our 4 questions here in just a little bit after we get done with our question discussion.
I think given that, taking that into consideration, the fact that it's been combined, and that he owns the land on the other side, that if push comes to shove, he can widen it into his own property and get the access that he wants. So it really doesn't impede his future plans if he really wants to do one.
I may have backed us into a corner here. I asked for a motion in a second. How about if we and we need to go back and ask our 4 questions. How about if we call the question on this and deny it, and then we'll ask our 4 questions, and go through formally. So, I have a vote on the issue before us. All those in favor say aye. All those opposed? Okay, so we've done away with that motion. Now, to decide the issue. Our first question is, there are extraordinary and exceptional conditions pertaining to the particular piece of property. Do I have a motion in the affirmative, please?
So moved.
Second?
Second.
Is there a second? Okay, discussion.
Well, she established a home
Yep.
site. She established her life is right there. He came in a year later and wants to change everything. So what I'm seeing is she was there first. He had to see it when he bought the property. If he didn't like it, he should have stopped it at that point.
Okay, so we're talking about the front stoop, the front porch.
Right.
That does, in my mind, that does encroach on the setback.
It does.
Technically. So we need to decide, is that allowable? So we're going to grant a variance for
I
that.
think it's a very minor encroachment at 3 to 4 feet.
I'd agree. See that we're talking about
And again, it was pre-established over a period of time, so it's a minor infraction that's been in place for the better part of 2 years or better.
Okay, we have a motion and a second. All those in favor that there are extraordinary and exceptional conditions, please say aye. Okay. 4-0, there are no noes. Second question, these conditions do not generally apply to other property in the vicinity. Can I have a motion, please?
So moved.
Is there a second?
Second.
Discussion? It's really the only property in the vicinity.
Yeah. It's self-evident.
All those in favor, please say aye. Raise your hand. Passes 4-0. Because of these conditions, the application of this chapter to the particular piece of property would effectively prohibit or unreasonably restrict the utilization of the property. Motion,
So
please.
moved.
Is there a second?
Second.
Discussion.
Well, I think code requires her to have a stoop on the back.
Yeah.
So by taking it away, then she's going to be non-compliant on something else. It's there, leave her alone.
I think with a mobile home, you have to
I don't know that for a fact, if that makes sense.
I believe it's a law. I think you have to, and certainly makes a lot of sense with a mobile home.
Okay. Call the question, please. All those in favor say aye. 4-0, there are no noes. The authorization of variance will not be of substantial detriment to adjacent uses or to the public good. And the character of the district will not be harmed by the granting of the variance. Have a motion, please.
So
Is
moved.
there a second, please?
Second.
Discussion.
I feel like that's what we've been talking about for the past
Oh,
30 minutes.
yes.
around. Yeah.
Given the current set of circumstances, I think there is not a substantial detriment.
No, not for the
Could be.
driveway.
I understand the folks' concern about, hey, if we want to develop a property, we got to do something here. We're restricted, we can't get through, but
But as a driveway, it's
the driveway is just, it's not a
non-issue.
Well, that's all we can consider it as, because we do not have a plat showing his proposed development.
So, all those in favor of the authorization of variance will not be a substantial detriment. 4 in favor, no opposed. So finally, based on the evidence presented to the board, do I hear a motion that the proposed variance be approved?
So moved.
Second.
All in favor, do you have any discussion? All those in favor say aye.
Aye.
Aye. Approved 4-0. The variance has been approved. Case is closed. I have a motion to adjourn.
So moved.
Second.
Favor? Out of here. Okay.